Rapper Lil Durk, who has won a Grammy, went to court to ask a judge to let him out of jail while he waits for his trial. He's being accused of putting a reward on a rival rapper that led to a shooting in Los Angeles back in August 2022. During that shooting, the cousin of the rival rapper was killed. At the court hearing on Monday in downtown LA, the judge, Michael Fitzgerald, didn't make a decision yet. The courtroom was packed with Lil Durk's friends and family, who came to support him. By the way, Lil Durk's real name is Dirk Banks. The judge said that even though Banks offered $4.5 million as bail, it wasn't enough to make him sure that the 32-year-old rapper from Chicago would show up for his trial. The judge thought Banks might have too much money to risk staying out of trouble. At the same time, the judge also said the prosecutors didn't show enough proof that Banks was part of the murder-for-hire plan. So, he wasn't fully convinced that Banks needed to stay in jail until the trial. The judge said they need clear proof to show the defendant was really involved. It's possible other people acted on their own to try and impress him. Back in October, Banks was arrested in Florida. He's accused of planning an attack in 2022 at a gas station in Los Angeles. The attack was aimed at rapper Quando Rondo, and sadly, it led to the death of Quando Rondo's cousin. A man is in big trouble because he's accused of being part of a plan to hurt someone. Police say he was involved in a conspiracy to kill Saviaya Robinson. 5 other people who are part of a rap group called Only the Family, OTF, are also in trouble for this case. Saviaya Robinson's mom came all the way from Savannah, Georgia, to Los Angeles to speak in court. Back in April, Banks asked the court to drop the charges against him. He said the government told the grand jury something that wasn't true. The government had said Banks wrote a rap song celebrating a revenge killing after Quando Rondo's cousin was shot. But Banks explained that the song was actually recorded 7 months before that even happened. After that, the government changed the charges and took out anything about the rap lyrics. Still, Banks' lawyers wanted to see what a key witness, probably an FBI agent, told the grand jury. They said the agent gave the jury wrong information. Banks' legal team also said the prosecutors didn't do enough research and gave out details that weren't accurate. The judge said he would think about the request and decide later. The prosecutors warned the judge not to share the grand jury testimony because it could put the witnesses who helped with the case in danger. Banks is a big name in music. He won a Grammy last year for Best Melodic Rap Performance for his song All My Life with J. Cole. He's also been nominated 3 other times and worked with Drake on the hit song Laugh Now Cry Later. So the government decided to act all tough, but I want you to really pay attention to how they're feeling. Let's talk about it. Okay, first off, listen up. This all happened yesterday. This is about the United States District Court in California. The government is responding to a motion from a guy named Banks. He wants to get the charges against him dropped. Sounds like he's trying to make the case go away. Let's see how this plays out. The government sent a paper to explain why the case shouldn't be dropped. In it, they share their reasons and try to show the court why the charges should stay. Drew looked at what they wrote and explained why their plan is really smart. The paper lays out a bunch of clear points and evidence to make their case stronger and easier to understand. So here's the deal. Yesterday, a file was e-filed, even though it's dated May 29th, 2025. That clears things up, right? Now let's talk about what's going on. The defendant filed a motion to dismiss something called the First Superseding Indictment, FS1. But since then, there's been a new indictment called the Second Superseding Indictment, SS1. This new one adds a charge for stalking that led to someone's death. Plus, it took out a part about the defendant's lyrics talking about greenlighting murder. Because of this new indictment, the defendant's old motion to dismiss doesn't really matter anymore. He even admits that himself. But now, instead of sticking with his original argument, the defendant is trying something new. He's saying that the grand jury records might help him get ready for trial or could be useful for impeachment. Basically, he wants access to those records, even though the rules say they're usually supposed to stay secret. The defendant is asking for something that doesn't have a good reason behind it. It's like going on a fishing trip without knowing if there are even fish in the water, just guessing and hoping to find something. The rules from the Supreme Court and other courts say this kind of guessing isn't allowed, so the request should be denied. Grand juries are supposed to stay secret so they can do their job the right way. If someone wants to see grand jury materials, they have to prove they really need them, and that this need is more important than keeping the secrecy. This is a big deal, and it's not easy to meet this requirement. The defendant's new arguments, saying they need the information to prepare for trial, don't prove they have a strong enough reason to break the rules of secrecy. The Supreme Court has said that just wanting to get ready for trial isn't a good enough reason to break the rules and share grand jury secrets. This is what the defendant is trying to do here. The defendant says he should be allowed to see grand jury testimony about a song mentioned in the case because he thinks it will show big problems with how the investigation and trial were handled. He claims this would help with pre-trial motions and his defense during the trial. But based on what he's asking for, the request doesn't show a strong enough reason to break the rules of keeping grand jury information private. The need to keep those secrets safe is much more important. Let's talk about grand jury materials. In one case with Procter & Gamble, the court decided not to let people use grand jury materials to get ready for a trial. Then there was another case, Reisman versus United States, where someone asked if the rules could be changed to allow this, but the answer was no. In yet another case, United States versus Rio, the court said that preparing for a trial isn't a good enough reason to share grand jury information because keeping it secret is more important. Let's talk about the case United States versus Taylor. The main issue here is about keeping grand jury testimony private. The court said that it's hard to think of something more general than just saying you need this information to prepare for trial. If every defendant could claim that, it would ruin the rules that keep grand jury secrets safe. The defendant also argued that he really needed this information because it would be unfair to go to trial without it. He said it could help him prove some witnesses were lying, but the court didn't agree. The rules say that if you need grand jury testimony to prove someone lied or to refresh a witness's memory at trial, that's okay in some cases. But just guessing that a witness might be lying isn't enough to break the secrecy of the grand jury, so the court didn't allow it. In the case of United States versus Hollis, the court decided there wasn't enough reason to believe releasing grand jury information was necessary. They said it wouldn't help in this situation and could hurt the grand jury process. This is especially true since no witnesses have testified at trial yet. Plus, the government has to follow certain rules, like sharing important evidence and being fair before and during the trial. The court explained that just saying you need grand jury testimony to catch someone in a lie or help them remember something isn't enough. You have to show real proof, like actual mistakes or trouble remembering. Without that, the request to see grand jury testimony isn't allowed, but the government still has to share this evidence later if it's needed under the law. The defendant didn't really argue against these rules, and instead brought up cases that don't apply here. For example, in Dennis versus United States, the Supreme Court allowed grand jury information to be shared only because key witnesses had already testified at trial, and one admitted to being wrong about important dates in earlier statements. The Ninth Circuit has made it clear that defense lawyers can't just go on a fishing trip to find whatever they want from witnesses' statements before trial. In the case of United States versus Kim, the court said the rules don't allow that. The case United States versus Reed doesn't apply here either because it dealt with a specific exception to the grand jury secrecy rules, which isn't relevant in this situation. The defendant already admitted that this rule doesn't apply, so there's no need to go through it in detail. Also, the claim that the government definitely presented false evidence to the grand jury is a stretch. It's more of an assumption than a sure thing. The defendant seems to think a grand jury witness mixed up their lyrics with SR's murder, but that doesn't prove anything about false evidence.